Hello everyone. I am Dr. R.Brinda Shree, Assistant Professor of Commerce, Sri Shada College for Women, Autonomous, Salem 16. In this video, we are going to discuss about the topic classification of contracts in the subject commercial law. First, we have to know what is law. Law means rules and regulations. So, the rules and regulations which are involved in commercial activities, that is, business activities, are termed as commercial law. Before entering into the main topic, that is classification of contracts, let us see what is contract. We heard about various acts which are implemented by the Indian government. For example, Indian Partnership Act, Indian Companies Act, Consumer Protection Act, Negotiable Instrument Act, and so on. Are you heard such type of acts? Yes. These are the acts which the government implemented to safeguard the people who are involved in it. Likewise, here we have Indian Contract Act 1872. This act was formulated in the year 1872 with the objective of safeguarding the people involved in the business contracts. The Act defined the term contract as agreement enforceable by law. Here we have to coin two terms to get the clear meaning of the term contract. What are the two terms? The two terms are agreement and enforceability. First, let us see what is agreement. So, agreement means a promise between two parties, that is, offerer and acceptor. Offerer is a person who promises to give some products or services, and in turn, the acceptor is one who is ready to accept the offer given by the acceptor. So, now we can clear about what is agreement. It is a promise between two parties. The next thing is enforceability. The agreement enforceable by law is called contract. So, enforceable means able to execute or able to impose. Therefore, the agreement between offerer and acceptor which can be executed, that is permitted by law, is called contract. Next head is obligation of contract. Obligation means duties and responsibilities. So, the duties performed by parties of contract are given under this head. That is obligation of contract. It includes payment details, delivery of goods details, and quality details, and other general principles which are involved in the basis of contract. So the obligation is very important, where the parties can know what are the basic rules they have to follow. The next thing is nature of contract. In India, all the business contracts are under the regulation of Indian Contract Act 1872. That's why we are following the Indian Contract Act 1872 in commercial law. So here, the rules and regulations which are to be followed by the parties while entering the contracts are given in a detailed manner. Here, we have to follow two aspects. That is, Indian contract as based on two aspects. One is general principle, another one is special contracts. So, according to Indian Contract Act 1872, Section 1 to 75 deals with general principles, and Section 124 to 38 of the Act deals with special contracts. Special contracts includes contract of indemnity, contract of guarantee, contract of bailment, contract of pledge, and contract of agency. The next one is separate acts. These are the acts which do not come under the Indian Contract Act 1872. That's why they are called as separate acts, that is individual acts. Some of the individual acts are Partnership Act 1932, Sale of Goods Act 1930, Negotiable Instrument Act 1881, and Insurance Act 1938. Yes, next we move on to our main head, classification of contracts. The contracts are broadly classified into three categories. The basis of classification of contracts are validity, formation, and performance. First, on the basis of validity, it further subdivided into valid contract, voidable contract, illegal agreement, and unenforceable contract. Second, on the basis of formation, it's subdivided into express contract, implied contract, and quasi contract. And the last category, on the basis of performance, it is subdivided into executed contract, executory contract, unilateral contract, and bilateral contract. Let us see one by one in detailed manner. First one, on the basis of validity. In that, the first thing is valid contract. The name itself indicates it is legally or officially accepted one. While using checklists or dialing mobile numbers, we hear this term frequently, isn't it? If the number is not valid or check is not valid, then it is called as invalid one. So, a valid contract is a contract which is executed by law. Here we have an apt example for this. Let us see the example. Mr. A and Mr. B enters into agreement stating that Mr. A offer his horse to Mr. B for rupees 50,000 and Mr. B ready to accept the offer by buying the horse at the same price quoted by Mr. A. Then the contract is said to be valid one because here there is a valid offer and valid acceptance. So this type of contract is called valid contract. Next one is void contract. It is just opposite to the valid contract, that is invalid one. Indian Contract Act 1872 defined the term person. That is, it is stated that the people who are capable of entering the contracts. So the person of sound mind and major, that is, person who attained 18 years of age are capable of entering the contracts. So the contracts entered with such type of people only a valid one. The contracts which are entered with minor person, that is below 18 years of age, and people of unsound mind like drunkards, lunatics, are not accepted by law, and hence it is termed as void contracts. They are not enforceable in the eyes of law. Next thing is voidable contract. Voidable refers to a contract which may or may not be valid according to the time being. Due to some legal reasons, the valid contract may enter into the stage of void one. For example, a misrepresentation of facts or exaggeration of facts or information by one party which initiates the opponent party to enter into the contract. Maybe a fraudulent activities are undertaken by a party to make another person to sign the agreement. Later, the opponent party may reveal the truth and cancel the contract. So this is a voidable contract because at the time of signing up, the contract is valid. But after revealing the truth, the contract is void. Fourth one is illegal contract. In simple, the contract which is not legal is called illegal contract. The contract entered by the parties which are against the law or against the moral values are termed as illegal contracts. So illegal things. We heard about illegal activities. That is, the activities of dealing in harmful goods, smuggling, gambling, theft, and forgery are some of the examples of illegal activities. There are some difference between illegal contract and void contract. Before we explained about the void contract, isn't it? So the void contract and illegal contract seems to be more or less a similar one, but there are certain differences between these two. That is, void contract is entirely different from illegal contract. Let us see the difference between the void contract and an illegal contract. Void contract is not prohibited by Indian Penal Code, that is IPC, but illegal contract is prohibited by the IPC from the very beginning of the contract. The term void ab initio is mentioned in the Act for illegal contract, which denotes the contracts which are entered as illegal, that is, illegal contracts are void from the very beginning, that is, signing of the contract itself, it is termed as void one. So, illegal contracts are always prohibited by the law. Fifth one is unenforceable contract. That is, these contracts are not enforceable. As this name suggests, these are the contracts which are not enforceable by law. This may due to some technical or clerical errors. The contract can be enforceable only if it fulfills all the legal formalities. So while entering into a contract or while doing business or while registering the business, we have to follow all the legal formalities. So In contract also we have to follow some legal formalities. The legal formalities like stamp duties, signing by the parties, process before the stipulated period time, etc. are to be followed. In case if any default in the legal formalities, then the contract cannot be enforceable. So such type of contracts are called unenforceable contracts. So after rectifying all these mistakes, like after paying a stamp duty or signing the documents or changing the policies, so then the later the contracts may be enforceable by law. So at the time being of in default, the contracts are unenforceable. After rectifying mistakes, it can be enforceable by law. Second major aid, that is on the basis of formation. Here the contracts are classified into express contract, implied contract and quasi contract. First let us see what is express contract. Express means deliberate. It is a normal term which we used in our routine, isn't it? So express contract is a contract where the offerer and acceptor stated the terms and conditions of a contract without hiding any terms. For example, Mr. Krishna sells his bike to Mr. Sen, stating the price, mileage, engine capacity, dispatch details, etc. Then Mr. Sen also accepting all the terms quoted by Krishna by saying yes. Here, both Krishna and Sen express their views on the basis of their opinion without hiding anything. So, this is a good example of express contract. Here, there is an express offer and express acceptance. Both the parties show their willingness expressively. So, such type of contracts are called express contract. Next thing is implied contract. A contract which is not expressed by words are called as implied contracts. So, it is just opposite to the express contract. The terms and conditions of a contract are just mutually understood by both the parties without stating that. Because here the offerer and acceptor understand the situation and act according to that. For example, if a person hire taxi, it is implied that he or she will pay the taxi fare to the taxi driver without hesitating the acceptance. I will say one more example for your better understanding. If you are visiting a restaurant and place some orders, after you dine in, bearer keep the bill in your table without saying anything, isn't it? So, it is implied that you have to pay the bill for the dinner you had in the restaurant. Now you are clear what is express and implied contract. Yes. Next, move to the quasi contract. Quasi contract is not at all a mere contract created by both the parties. So far we discussed the contracts or the agreements between two parties, that is offer and acceptor. But here the contract is not created by the offerer or acceptor. It is created by the court of law. Nowadays this type of contracts are quite normal. For example, Mr. Arjun ordered mobile phone in Flipkart, but by mistake the parcel was delivered to Mr. Veer. Now, Mr. Veer has to return the parcel to Flipkart delivery boy. Suppose if he fails to return it, then the law enters between these two people, that is, between Arjun and Veer, and ordered Veer to return back the parcel to Arjun, or he has to pay for it. So here, Arjun and Veer not known to each other, not a mere offerer and acceptor, but law creates a contract between them. Such type of contracts are quasi contracts. So it is very clear that quasi contracts are the contracts created by the court of law in case of any loss occurred to some people by other people. Maybe a compensation given by one party to the affected party. Third main head, on the basis of performance. So on the basis of performance, these contracts are subdivided into executed contract, executory contract, unilateral contract and bilateral contract. So in the first thing is executed contract. It is a contract where both the parties of a contract completed their performance. That is, they fulfilled their obligation. For example, rendering repairing services of Mr. A's car by Mr. B. Mr. B repairs the car. In turn, Mr. A pay the repairing charges. Here, both the parties completed their obligation. So, if the parties completed their full work or they entirely completed the obligations of a contract, then the contract is said to be a executed contract. Next one is executory contract. Here, the part of a contract or the entire contract is to be performed in future. So, it is not fully completed like executed contract. It is also termed as partly executed and partly executory contract because in some cases the part of a contract will be executed in future and part of the contract already executed. That's why it is termed as partly executed and partly executory contract. Paying apartment lease is the best example of executory contract. Third one, unilateral contract. Uni means one. It is a one-sided contract where one party performed its obligations and other party has to perform its contract after some period, that is in near future. Sometimes in unilateral contract there may be one side promise by the offerer to the acceptor. If offerer promises to pay or render services in near future and acceptor also accepted that, then it is called unilateral contract. For example, if Mr. A promises to pay rupees 10,000 to Mr. B, that is acceptor, if Mr. B, that is acceptor, completes his task, then it is called unilateral contract. So here one person promises to pay to the other person if another person completed the work. Here there is one promise. So it is called one-sided contract or unilateral contract. Next one is bilateral contract. It is just opposite to the unilateral contract. That is, bi means two. So here there will be a mutual promises between both the parties. That is between the two parties, offerer and acceptor. Offerer promises to offer, in turn, acceptor promises to accept the offer. For example, Mr. X, an offerer, promises to lease his house to Mr. Y, an acceptor, if he pays rupees 20,000 monthly as rent. If the acceptor accepts the offer and promises to pay the rent, then it is called bilateral contract. Here, both the parties exchange their promises. It is not one-sided. Here, both the parties in turn exchange their promises. Offerer also promises to offer the thing and acceptor also promises to accept the thing. Then it is called a bilateral contract. Apart from this main classification of contract, there are some other contracts. They are contingent contract and wagering agreement. First one, contingent contract. Contingent means may or may not happening. So, in this type of contract, the performance or non-performance of a contract is based on the happening or non-happening of certain events. So, Indian Contract Act 1872 in section 31 defines the contingent contract. It explains that if some event collateral to happening or not happening, then it is called a contingent contract. Contract with insurance companies are good examples of contingent contract. If a person takes a bike insurance, then the insurance company will pay the insured amount to the insurer if there occurs any accidents or losses and any injuries to the bike or a riding person. If nothing happens to the bike, then insurance company is not liable to pay the insured amount to the insurer. So here the contract is based on the happening or not happening of any losses or damages to the bike. So this type of contracts which is based on some events whether it happens or not, that is based on outcomes, then it is called contingent contract. Next one is wagering agreement. Literally, the word wagon means bet or gambling. The agreements which are based on the bet, luck of win, gamble, are termed as wagering agreement. Here, there is a equal chance of both the parties, that is, either to win or lose, depending upon the outcome of future events. Hence, the events are futuristic, it cannot be controllable or predictable. Section 30 of Indian Contract Act 1872 deals with this type of wagering agreements and stated that wagering agreements are always void. As it is based on gambling, it is not a valid one. So, the parties involved in wagering agreements are not entitled to claim any recovery in case of default or any fraudulent activities. Example of wagering agreement is if X and Y enters into agreement, that is, Chennai Super Kings wins, X will pay rupees 50,000 to Y. So it is a mere gambling or betting. It is implied that Y will pay rupees 50,000 to X if the situation reverse. So here both the parties have a equal chance of winning rupees 50,000. So these type of contracts based on luck or winning of a game or gambling are termed as wagering contract. There are some differences between contingent contract and wagering agreement. So far we discussed what is contingent contract and what is wagering contract. With this, we can note the differences between these two. In wagering agreement, there is a reciprocal promise. But in contingent contract, there is no reciprocal promise. Parties in the wagger agreement have no interest in the subject matter. Just they think we have to win the game. But in contingent contract, the parties involved may have interest in the subject matter. So these are the basic differences between the wagering agreement and contingent contract. So far we discussed various classification of contract. Let us see the little recap on this topic. Contract is an agreement between two parties, that is offer and acceptor, which is enforceable by law. And the main topic, classification of contracts. In classification of contracts, the contracts are broadly classified into validity, formation and performance. In validity, we have 5 classifications: valid, void, voidable, illegal and unenforceable. So valid contract is a contract which is enforceable by law. Void contract is not enforceable by law, it is always invalid one. Voidable contract, so it may or may not be void or valid. Next thing, illegal agreement. So the contracts which are entered for illegal activities are called illegal agreement. And the last thing, unenforceable. So due to some cases the contracts are not enforceable by law, then it is called unenforceable contract. The second category, on the formation, it is subdivided into express contract, implied and quasi. Express means both the parties express their terms and conditions. But in implied contract, they did not express anything. They have to understand by the situations. And the last thing, quasi. Quasi means it is a contract created by law. It is not created by the offer and acceptor. Yes, it's clear? Yes. And the last thing, performance. On the performance, it is divided into executed contract, executory contract, unilateral and bilateral contract. Executed means already completed or already performed. Executory means a part or the full contract to be executed in near future. Then unilateral contract, it is a one-side promise. And bilateral, it is a two-side promise. That is, both the parties, offer and acceptor, exchange their promises. Finally, on another contracts, we have contingent contract and wagering agreement. Contingent means may or may not happening. That is contract based on happening or non-happening of certain events. Next thing, wagering. Wagger means betting or gambling. The contracts based on gambling are termed as wager agreements, and it is not void from the very beginning. So, in nutshell, we discussed all the things. I hope from this video you are clear on the topic classification of contracts. Thanks for your patient listening. Thank you.